Welcome to this week's knowledge clip for public international law. Today we will be discussing the case of Belgium versus Senegal. This case deals with questions about jurisdiction, prosecution and extradition. The case revolves around Mr. Habre. Mr. Habre was the former dictator of the Czech Republic. It is alleged that he has killed over 40,000 people during his reign, which has infringed on the Convention Against Torture by committing crimes against humanity, under which torture and genocide. After being ousted in a coup, Mr. Habre fled to Senegal, where he was granted asylum in 1990. There are 5 main actors in this case. First, Mr. Habre, the country of Senegal, the Convention Against Torture, Belgium, and the International Court of Justice. These actors got involved in the following way. Mr. Habre fled to Senegal. Senegal, as a contracting party to the Convention Against Torture, was supposed to make an inquiry into the facts of the crimes which were allegedly committed by him. However, Senegal failed to do so. As another contracting party to the Convention Against Torture, Belgium then requested the extradition of Mr. Habre from Senegal, which means that Mr. Habre would be sent to Belgium to be trialed. However, Senegal failed to prosecute as well as extradite Mr. Habre. After a 10-year delay, Belgium finally referred the case to the International Court of Justice, asking if Senegal had failed in its obligations. But before we go into the court case, let's look at a timeline and the relevant factors in this case. The case starts in 1990, when Mr. Habre flees to Senegal. It is 10 years later that 7 Chadian nationals request of Senegal to prosecute Mr. Habre on the alleged crimes against humanity. However, the Senegalese court states a year later that it does not have jurisdiction to deal with this case, and therefore dismisses the case. Belgium consequently launches their own investigation and 5 years later requests the extradition of Mr. Habre. However, Senegal states that it has referred the case to the African Union and cannot extradite Mr. Habre at this time. After the African Union has taken the decision that Senegal is obligated to prosecute Mr. Habre, Senegal has to make legislative changes and makes a request for international funding to finance the trial. Finally, after the delay arises from the funding issues, Belgium refers the case to the International Court of Justice. But let's first start in 2000, when the 7 Chadian nationals complained before the Senegalese court, stating that Mr. Habre should be trialed. The Senegalese court finds that it does not have jurisdiction. Why? According to Senegalese law, a court cannot establish jurisdiction if the crime is committed by a foreign national against foreign nationals in foreign territory, which is a codification of the active personalization, passive personalization, and territorial principle. Senegal then decides that since the law does not permit them to have jurisdiction, they must dismiss the case. However, this does not mean that the case ends for Mr. Habre. In Belgium, a Belgian Chadian national complains before the Belgian court about the same crimes committed by Mr. Habre. Belgium, as a contracting party to the Convention Against Torture, then launches an investigation into the alleged crimes. After 4 years, Belgium finds enough evidence to request the extradition of Mr. Habre. However, Senegal refuses this extradition. Senegal states that it has referred the case to the African Union and that it must await this decision. After the African Union decides that Senegal must prosecute, they decide to change their law. First, Senegal changes its national law by establishing jurisdiction over crimes which fall under the Convention Against Torture. However, it says that Mr. Habre is still excluded from the scope of Senegalese law, since the legislative change took place after the crimes were committed or alleged against him, therefore invoking the principle of non-retroactivity. In 2008, Senegal changes its constitution to exempt the principle of non-retroactivity in case of crimes against humanity involving torture and genocide. Therefore, Senegal now has the legal capabilities to prosecute Mr. Habre. However, Senegal now invokes financial problems and requests funds from the international community in order to have the trial occur. Senegal requests 27.4 million from the international community. However, it receives only 8.6. This causes a further delay in the trial of Mr. Habre and in the prosecution of Mr. Habre. When in 2009 still nothing has happened, Belgium launches a court case before the International Court of Justice. In this case, Belgium asks 3 questions. 1. Did Senegal fail in its obligations under Article 5, Section 2 in the Convention Against Torture by not establishing jurisdiction timely? 2. Did Senegal fail its obligations under Articles 6 and 7 of the Convention Against Torture by not launching a preliminary inquiry into the facts and by not consequently prosecuting or extraditing Mr. Habre? And 3. Can Senegal indeed rely on financial problems in order to relieve themselves from obligations under the Convention Against Torture? Regarding the first question, Article 5, the court states that even though every member state or every contracting party has an obligation to establish jurisdiction, and Senegal did not have jurisdiction at the beginning of the case, the point of contention between Belgium and Senegal has already been resolved. It states that due to the legislative changes, Senegal now has shown willingness to make sure that the legal methods are correct to establish jurisdiction. Therefore, the court no longer finds it necessary to decide on this point of the case. However, regarding the Articles 6 and 7, the court does give an interpretation. Regarding Article 6, the court states that it is an obligation on a contracting party of the Convention Against Torture to launch a preliminary inquiry into the facts to ensure prosecution at a later stage, if necessary. Senegal has failed this obligation during 1990 to 2000, when it did not launch such an inquiry into the facts, or did not show that it had launched such an inquiry into the facts. Then, Senegal has also failed their obligations under Article 7. Article 7 states that a contracting party must either prosecute or extradite. The wording of this article is shall, and therefore it shows that the Senegalese government had little jurisdiction in deciding on it. It is quite normative. Now, this means that Senegal had an obligation to prosecute Mr. Habre according to the court. The question is, can they be relieved by a request for extradition? Here the court states that when there is a request for extradition, it can relieve a contracting party if they decide to extradite, but if they do not extradite, the obligation to prosecute remains. Therefore, Article 7 is the exception where a country can be relieved from its obligation to prosecute. Regarding the financial problems, the court stated that Senegal could not rely on financial difficulties to relieve themselves of the obligations under the Convention Against Torture. Therefore, Senegal had to swiftly start with the prosecution or extradition of Mr. Habre. The court's final decision was in the favor of Belgium, stating that Senegal was and remained in breach of Articles 6 and 7 under the Convention Against Torture. Therefore, Senegal had to start their prosecution swiftly. The case ended on the 30th of May 2016, when Mr. Habre was indeed sentenced to life in prison. This was a huge victory for the African continent, since this was the first time that a regional arbitration court was used to sentence a former dictator on the continent. Now, during the case we saw 2 other jurisdictional issues. The first one was about the immunity of a head of state. However, the court stated that the successor of Mr. Habre in 1993 waived his right to have immunity as a head of state. Therefore, Mr. Habre could not enjoy it anymore. Another jurisdictional issue was for the establishment of the jurisdiction of the International Court of Justice itself. Belgium invoked Article 30 to make sure the court had jurisdiction, since it could not rely directly on Articles 5, 6 or 7. This leads to the central question that students will have to answer this week. What were the conditions that needed to be satisfied for the court to establish jurisdiction? And what does this say about the nature of international law and international relations? Thank you for your attention.